Okay. Good afternoon, everyone. I'd like to start by welcoming everyone to January 25th, 2021 Planning Board hearing for the town of Brookhaven. I'd like to begin with a roll call. Mr. Zarcone.
Present.
Ms. Kelly. Ms. Kelly.
Present.
Call me cell 631-478-3564. Bye.
Mr. Walutis.
Present.
Ms. Dunn.
Present.
Mr. Smith.
Present.
Mr. Rose.
Present.
I'm Vincent Pascal, Chairman, present. With us, we have Counsel to the Planning Board, Ms. Lee Ray, Commissioner of the Planning Department, Ms. Beth Riley, and Secretary to the Planning Board, Ms. Eileen McCallion. Ms. McCallion, are there any items on the agenda that will not be heard this afternoon?
Yes, Mr. Chairman, item number 520 William Floyd LLC has requested to be adjourned until March 8th, 2021.
Okay, so if anyone is on the meeting for the agenda item 520 William Floyd LLC at Shirley, that's going to be held on March 8th. Thank you, Ms. McCallion. I'd like to begin with item number 1. It's the relief of covenant, Sunset Bluffs, lot number 28 at Miller Place. Is Commissioner?
Application is relief of covenant to allow for one additional building lot for lot 28 on the file map known as Sunset Bluffs at Miller Place. This is being held from a previous meeting. This is the second time we're seeing it.
One moment so I can bring the applicant in.
Good afternoon, Mr. Chairman, members of the board. My name is Christopher Modeleski. I'm an attorney with offices at 44 Elm Street in Huntington. I'm here this afternoon along with retained real estate expert John Breslin on behalf of the applicant before the board. I had submitted previous to this afternoon's board meeting both a memorandum of law with a number of exhibits attached thereto, some substantive law that I asked the board to take notice of. And in addition to that, an affidavit by letter from a builder contractor with respect to the somewhat peculiar nature of the northerly portion of the subject property, which is before the board for relief of covenant. I have previously shared all of these materials with Mr. Davis, who appeared before the board back on the 11th in opposition to the application. In response thereto, Mr. Davis shared with me the actual filed declaration of covenant restriction that I believe he plans to introduce before the board this afternoon. What I had tried to do, Mr. Chairman and members of the board, is to be as succinct as possible and to make the lion's share of my legal and factual arguments in writing in an effort to make the Zoom presentation a little bit less cumbersome for all of us. But there are a few things that I think I should probably just highlight in my remarks, if that's okay by you.
That's fine. Counsel, I received that email and I read through it. I was wondering, did the rest of the board receive the email that the counsel sent?
Yes,
I did.
Okay,
Yes.
okay, they got it. Thank you, Counselor.
Yes.
Thank you, Mr. Chairman. You know, land use is a pretty genteel practice and it's a pretty small bar. So as I said previously, I shared materials with Mr. Davis. He shared in kind with me. I did listen to his presentation and I heard the colloquy back and forth between himself and Ms. Moget and board members on the substance of the application. It appears to me to be a rather benign request before the board. There are certain challenges from an engineering and construction standpoint that present, but all of those are peculiar to what is denominated as proposed parcel 1 or lot number 1. And they will have no effect or if anything, as Mr. Breslin points out in what I believe will be his remarks, and I know is in his written report, which was submitted today to the board, a salutary effect, a beneficial effect on adjacent properties. And I would, because I'm bearing the burden of proving entitlement to the relief sought, because I represent the applicant, I would just ask respectfully if I might have the last word following on Mr. Davis's comments and argument. But let me just address what I think he's going to say with respect to the actual filed declaration of covenant and restriction. I suspect, because he and I chatted about it, that he will make an argument that the covenant and restriction is a contract, an agreement by and between the original declarant and the town of Brookhaven Planning Department. And that because the balance of 27 or 28 other property owners included within the ambit of the original subdivided parcel are not before the board, that the board cannot grant the relief that's requested. I could not disagree respectfully with my colleague, Mr. Davis, more emphatically, and point out to you that that is absolutely and fundamentally wrong. I can't see any state Supreme Court judge agreeing with that as a matter of policy. The reason I say that is this board is vested with certain jurisdiction that comes from the state legislature and also from the legislative body in the town board. Included among that in section 85-109 is the authority to engraft or to vacate covenants and restrictions. I submit to you respectfully, and I've known Mr. Davis for a long time. We've worked together and against one another, and I hold him in the highest regard. But I think he's absolutely, utterly wrong when he suggests to you that you can make a deal as a private landowner and developer that will in the future abridge or restrict the statutory authority of this board. You just can't do that. It's not countenanced in the law. There's nothing in the case law of the state that would support such a proposition. And I submit to you that it is of no moment here and should be of no consideration or concern to you. Obviously, you can consult with counsel about that independently. But I think the application speaks for itself on the merits, both in terms of the palpable need for housing in the township of Brookhaven and in the county of Suffolk recently. And I don't have to tell all of you, you know what goes on in your own town. But the floating zone that was recently adopted by the town board, while it may have an anti-blight sort of an underlying policy to it, I think it's also self-effacing that change to the zoning code indicates the understanding and recognition by your own town board, the legislative body in the town of Brookhaven, that there is a need to create housing in the town. What we're proposing here is an utterly conforming lot with respect to zoning. Parcel number 1 will conform in all respects. Both of the parcels will be adequately sized in terms of the residential zone and the area requirements of that zone. The one very minor relief that we will be seeking, if this board grants relief of the covenant, is with respect to lot frontage for the already improved portion of the lot, which is parcel 2. I'll let Mr. Breslin speak more thoroughly and authoritatively with respect to that and whether or not that could be an adverse condition in the neighborhood. And as well, I expect him to talk a little bit about flag lots generally, which are found on the map in the neighborhood, and they function like flag lots, quite frankly. I was at the property. I also looked at the neighborhood conditions. Those flag lots that are a little bit to the west on Sunset Lane East, they may have frontage on 2 streets, but they function as flag lots. You will see mailboxes and garbage cans on the Sunset Lane East side, which is where those driveways come out for access to the public way. And they are in every respect, I think, when it comes to land use and what we understand a flag lot to be flag lots. So I don't see any undesirable condition being created as a result, but I'll defer to Mr. Breslin on that. As I touched on previously, I think there may be some engineering challenges with respect to developing the lot, but those challenges are easily met. They do affect the overall economics of the project because they will require that clean fill be introduced, that the fill be appropriately and thoroughly compacted, and that advertence to the results of that be turned over to the building official. As Mr. Stone pointed out in his affidavit letter to the board, the soil conditions will have to be sufficient to support haunch footings, basement walls, and all the ordinary incidents of a residential single-family dwelling. That's not difficult to do. It'll be more costly than a flat level parcel. But the idea that this property is somehow deserving of sterilization because in its natural contour, it's essentially over excavated, I think is an idea that just doesn't make a whole lot of sense in 2021. I'll entertain any questions that any member or council or the commissioner might have. But that's essentially all that I want to say on the case in chief, Mr. Chairman.
All right, Counsel, I'll bring you back after anyone from the public speaks, okay?
Thank you.
All right, Counsel Ray, do we have someone in the public wish to speak on this application?
Breslin, were you planning on adding? Okay, yes, just a moment, please. All right, have Larry Davis.
Okay, you bring Mr. Davis in or?
Yes.
Mr. President? Okay.
Can you hear me, Mr. Chair?
Yes, Counsel, how are you?
I'm very well. How are you this evening?
Good, very well.
Good. So thank you for having us back. I did some additional research, as Mr. Modeleski had pointed out. And just for the record, I too hold Mr. Modeleski with the highest regard and have the deepest respect for him and his accomplishments through the years. And I appreciate his bringing this application, his best foot forward on this. But in reply to that, I am going to read an email that I sent to Ms. Rate earlier, I should say in the middle of last week, after I had spoken to Mr. Modeleski regarding this file. And I think it's clear that I read it in getting my words out and correctly where everybody will understand them. It's just going to say, good morning, Lee. I understand that Paul DeChance has hired Chris Modeleski to represent him on his planning board application on Monday afternoon. Please note that I'm going to ask the planning board to dismiss the action. I have enclosed a copy of the covenant that is being requested to be relieved of no further subdivision. Please note the last paragraph of the recorded covenant that provides these covenants shall run with the land subject to the right of the declarant with the consent of the town of Brookhaven to amend, annul, or repeal the foregoing covenants at any time. Please note that the applicant is not the declarant. The declarant is Sylvan Estates, Inc., which was signed by William Hine, president. Sylvan Estates, Inc. was dissolved by proclamation and annulment of authority on June 23rd, 1993. One could argue that the declarant's successor in interest would now have the authority to bring this application. If that is the case, then the applicant would need to prove that he is a successor in interest to Sylvan Estates, Inc. Otherwise, the successors in interest are the homeowners of each of the 28 lots on the filed map. Due to the fact that I represent two of those homeowners, the applicant cannot get the unanimous consent of all of the homeowners to be the applicant. Therefore, the action must be dismissed. Please contact me please contact me should you wish to discuss this matter. Please note that I provided Mr. Modeleski with this information. Thank you. In addition to that, Mr. Chair, I couldn't disagree with Mr. Modeleski more. His presentation and his memorandum that he sent to the board referred to cases that had factual differences to the case at hand. Those cases, one of the covenants was expiring and there was a balancing test that the courts imposed to remove the covenant. That's not the case here. This covenant's been in effect since since before the map was filed, and it was filed against each and every one of those 28 lots. To single out one parcel and make him the applicant and allow him the ability to remove a covenant that has been protective of everybody else in the community is not correct and should not be adhered to. Secondly, there has been, and I don't think in any of his presentation was there a showing of a change in circumstances within the physical character of that community. His changes in circumstances refer to a pandemic and refer to economic changes that have occurred in our economy. We have economic changes frequently throughout time. Does that mean every time we have an economic change that we should be bringing properties back to relieve them of covenants that they might have or might enjoy? All of the neighbors in that community have adhered to that covenant and enjoy the benefits of that covenant. To relieve one applicant just creates a problem for the rest of the community. And there may be other lots that may be also able to get relief of this covenant as well. So in essence, there's a problem, there's a Pandora's box that you may not want to open, because we may be able to open these all throughout the town of Brookhaven. This is not a single one lot, no harm, no foul type of thing. This is a problem, a precedent that can be set that will resonate throughout the rest of the town. There are many file maps, many cul-de-sac lots that have larger pieces of property. This is just one of many of those. In fact, there's also one in this community that is just at the very north end of this subdivision that could enjoy that similar relief and that similar relief of covenant. This community has not changed in 35 years. There's no reason to change it now. So again, my comments from the previous hearing, I know are incorporated, so there's no sense reiterating all of that. I just asked the board to dismiss this action because I truly believe a covenant is a promise that is to be kept by all the parties. The town of Brookhaven did consent to that covenant being filed. They gave the declarant the right to come back with the consent of the board. The proof is in the covenant itself. We need to adhere to contracts, and that's what this is. This is a contract. And to change the format of that contract is something that we should avoid at all costs. We need to continue the sanctity of a contract as it benefits many people. We have many covenants that run throughout the town. If this is to be defeated, then I believe we can defeat many more. And with that, I shall leave it to your decision, and I thank you very much for your time this afternoon.
Thank you, Counselor.
Mr. Chairman, can I ask Mr. Davis a quick question?
Oh,
Yeah.
sorry, I was taking him out. Hold on just a moment and I will put him back in.
This is Richard Smith, by the way.
Come back to us, Larry.
Am I back?
Yes.
Okay.
Mr. Davis, you had mentioned that there was one of the lot, you said to the north, that might take advantage of this, but is not the lot you're referring to, lot number 11, which is actually on the east side of this subdivision?
Yes, it is number 11, Mr. Smith. You're absolutely correct. It is to the east of the subdivision. I meant it's to the north of the application.
Okay, thank you very much.
Counselor Reed.
Okay, Larry, if no one has any other questions, then I'll bring him out. Okay, I would like to, though, comment that I did get his email. And I disagree also with his interpretation that all of the homeowners would have to sign off on any relief here. First of all, it's not actually a relief of covenant. It's the request is authorization per the covenant for the homeowner to look for a subdivision at the Board of Zoning Appeals. So it's not that the covenant's going to go away. It authorizes the homeowner to go to the Board of Zoning Appeals for a land division. And I understand what he's saying regarding the declarant, but covenants, the covenant is actually a benefit to the town. That's the town is the one who asked for the covenant. So the beneficiary of the covenant is the town, not necessarily the property owners that have come after that. That's how I just disagree with his interpretation of how the covenant would work. So I just want to address that.
Thank you. Are there any other members of the public wish to speak on this?
No.
Okay, can we bring Councilor Ludeski in?
Yes, he's there. Chris?
Yep, thank you, Lee. I'm sorry, Mr. Chairman, can you hear me?
Yes, we can.
Thank you very much. I don't want to take a whole lot of your time. Just one of the things that I did try to point out forcefully in the papers before the board is that this covenant lacks a purpose clause. I didn't just rely on the language that I saw, Mr. Chairman. I dug deeper because I thought I owed a debt of responsibility, professional responsibility to this board to see if there was anything in the minutes in 1984, circa 84 or 85, which would give a clear indication of what the board members had in mind when they had granted the covenant and whether it did pertain in particular to the subject lot, my client's property. I found nothing, and I submitted those 46 pages to you. So I rely on the posited legal authorities that I put before you, and I trust in your judgment and the great authority and discretion that has been vested in you, all of you, both by the state of New York and by the town of Brookhaven. There is nothing fundamentally wrong with recognizing that circumstances have changed in a community, and those circumstances are manifold when we're talking about planning. Remember that your jurisdiction is much wider and much broader than, for instance, that of the Zoning Board of Appeals. And we see that in the preamble to the enabling legislation that creates the planning board. So the planning board is absolutely free if it determines based upon prevailing conditions, be they economic or otherwise, that if something ought to be done because there's a good land use reason to do it, then you're free to make that decision. The fact that there is a palpable need for additional housing, that's not a matter of my opinion. It's something that we all recognize. It's something that your town board recognizes and understands. We're not asking you to do something in derogation of the rights of others. What we're asking for is the ability to develop real property the way that it was intended for a single-family residential dwelling, and abiding by with one very, very minor, narrow exception, which is the frontage relief that we'll need for the lot that's already developed. But we're asking overall to conform to zoning and to build a handsome single-family home that will benefit the neighborhood and certainly not detract from values of surrounding property owners. I was hoping that possibly Mr. Breslin was still around and we could hear from him before the board closed it out. He says to me by way of a text message just a moment ago, I am here. I think he's worth listening to if you give him a minute or two, and if it's technologically possible to get him in.
Mr. Chairman, can I ask Mr. Modeleski one quick question?
Certainly.
This is Richard Smith.
Yes, sir.
In this subdivision initially, although, as you noted, there are several that use flag lots to gain access from within the subdivision, but none of those lots actually needed a variance for lot frontage. Is that correct?
No, because they have adequate frontage on the street to the north.
So
Yes,
this
sir.
particular lot would be the only one that would need a variance for lot frontage.
Yes, but that's you're absolutely right. But that's a condition that has existed for many, many years since the homes were built. I mean, you'll notice another driveway next to a fully developed conforming lot. But that's exactly the same condition that you will notice for those two lots further to the west on Sunset Lane East.
No, I understand. My point was just that those other lots did not require the variance. They just set it up that way. This will act just like those other lots, but it will, in this case, require a variance.
Yes, sir. You are absolutely right.
Thank you very
Is
much.
that the minor variance you were talking about earlier, Counselor?
Yes, Mr. Chairman.
Okay. You want to bring Mr. Breslin in, Lee?
Yes, Mr. Breslin?
Yes, good afternoon.
Can you raise your right hand, sir? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay.
Again, my name is John Breslin. I'm the principal and president of Breslin Appraisal Company at 44 Elm Street, Huntington, New York. I was requested on behalf of the applicant to look at this proposal to allow this property to be subdivided as proposed. And in order to do that, they need relief from the covenant that was put on the original subdivision. This covenant that we're talking about is really what's a standard covenant that exists in all subdivisions. It says no lot can be re-subdivided without permission from the board. And it's important to note, I think, that it is that standard covenant and not a specific covenant that addresses this lot. And if you look at the covenants with respect to that 1984 subdivision, there are a number of specific covenants that talk about the physical characteristics of the subdivision and deal with specific circumstances, including those two flag lots that you mentioned. They talk about the requirement of the common driveway in connection with that. So there was no specific direction about the physical characteristics of this property and the reason why that this lot should not be further subdivided. And I think that's important to mention because a lot of times when you talk about the need or the requirement for covenants that you typically see with respect to development of subdivisions, when you're dealing with specific issues, they usually are for two reasons, either for physical characteristics or because the subdivider has already obtained their yield by spreading it out over the overall yield of the map, similar to a cluster. That's not the case here. There's ample acreage with respect to the development of this original map. I think, as was alluded to by Mr. Modeleski, it's really more of a practical consideration. Back in 1984, the economics didn't allow the filling in of this lot to make any economic sense. Today, however, it's different circumstance. This is a very nice neighborhood. It's worth it to do that. But I think from another practical consideration, the idea of filling this lot to the extent that you can develop will also help stabilize the hill for the homes that are on this street to the north. They're on very significant slopes. I believe that in some cases, retaining walls have been added to help stabilize those slopes. This will enable that to be further stabilized, which will be a significant benefit to those houses that back up to what would be a house on this lot. I think also aesthetically, it will be far more pleasing than instead of having a large open pit, as opposed to having a house on a generally level piece instead of the pit with trees coming out of it. So overall, I think it will be a significant upgrade to the look around there, plus the stabilization of the hill. The flag lot that this would create really is an existing condition. The driveway acts as a flag lot now. It's not inconsistent with what's in the immediate neighborhood already, not just the two that exist around the corner, but there are others. If you look at the tax map in the immediate area, that there are some other flag lots. Also, at the end of this block, the cul-de-sac adjacent to the driveway on the opposite side, there is a sump adjacent to what will be the flag lot driveway on its right or southerly side. And the house that abuts on the other side actually backs up to it and fronts on the corner of the other street. So the existence of these two lots, certainly size-wise, they're consistent with the pattern of development. They're certainly not going to opt to adversely impact property values. And I think there could be a positive increase to the immediate neighbors because you avoid the danger of the hills that abut it.
All right. Thank you, Mr. Breslin.
Thank you very much.
Counselor, you conclude your presentation?
I thank you. I thank you for your great indulgence, Mr. Chairman and members of the board. I don't have anything else. I appreciate you taking the time to listen to me.
You're welcome. Is there any board members have questions for Counselor? Seeing none, may I have a motion?
Mr. Chairman, this is Steve.
This is Steve Walutis. I make a
Steve
motion.
Walutis, I make a
to
motion to
hold this public hearing and place it on the decision.
and place it on the decision calendar.
Okay, motion by Mr. Walutis to close,
Mr. Chairman, Pete Zarcone, I'll second.
second by Mr. Zarcone. Ms. Kelly? Ms. Kelly? Ms. Dunn?
Aye.
Mr. Smith?
Aye.
Mr. Rose?
Aye.
Chair votes aye. Ms. Kelly? Motion carries 6-0 with one absence. Thank you, gentlemen.
Thank you very much.
Item number 2, the Woodlands at Port Jefferson Station.
The app, can you guys see it or did I lose it?
No, I don't see the,
Sorry. No, the application before you was for a clearing limit increase from 70% to 80%. The survey submitted depicts current clearing at 80%. Parcel is located outside of Old Town and state critical environmental areas. The lot size is approximately 15,000 square feet, and the additional clearing is to legalize an in-ground pool and a patio. Staff recommends approval of the clearing limit increase from 70% to 80%. A final survey submitted depicting current clearing limits, clearing percentages, and covenants submitted to Division of Environmental Protection. And prior to filing updated covenants, submit them to the Division of Environmental Protection for approval.
thank you, Commissioner. Counselor, is the applicant present?
Yes, I have Mr. Burrell.
Hello. Hello, Chairman. Can you hear me?
Yes, Mr. Burrell. Are you an attorney?
I am not. I'm a homeowner.
All right, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, you want to present the application to the board? Your request?
Yeah, so the request is to clear the increase the covenant from 70% to 80%. I was through the whole process relative to getting to the CO, but when I submitted my updated survey, the covenant, I guess, which my neighbor had gotten the covenant back in May of 2013, I guess, approved for 80%. It had stated that on my survey, but I spoke with Brooks Surgan. He said I had to go to get that officially done for my lot, because we have a lot of 61 homes that were built back in 2001 in the Woodlands, and this has been approved for a couple of my neighbors. I'm basically looking to get the same increase from 70% to 80% for my lot.
Okay, thank you. Counselor, is anyone in the public wish to speak on this application?
No, Mr. Chairman.
Any board members have questions?
No.
May I have a motion?
No.
Mr. Chairman, I make a motion to close this public hearing and place the matter on the decision calendar.
Motion to close by Mr. Smith,
Second.
second by Ms. Dunn. Mr. Zarcone,
I vote aye.
Ms. Kelly,
I vote aye.
Mr. Walutis,
I vote aye.
Mr. Rose.
Aye.
Chair votes aye. Motion carries 7-0. Thank you, sir. Item number 3 is a miscellaneous matters, Allied Physicians Group LLC at Rocky Point.
Property is located at 346 Rocky Point Road in Rocky Point. Zone J Business 2, and the lot area is 21.61 acres. The proposal is to split an existing vacant tenant space into 2 for proposed medical office, including minor facade modifications. Staff recommends approval of this request with 9 staff recommendations, last dated 11/20/2020.
Thank you, Commissioner. The applicant present, Counselor?
Berry?
We're waiting to get him in.
He's here now.
Hello.
Okay.
How are you? Jack Roseberry, architect, Roseberry Architectural Studio.
Good afternoon, Mr. Roseberry. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, Mr. Roseberry, you want to present the application to the board and the public?
What we're doing here is what we have here is it's a existing retail store located at 346 Rocky Point Road in Rocky Point. We are converting it to a pediatrics facility, approximately 5,000 square feet in area. We are constructing a door on the east wall of the building as far as facade modification and a small handicap ramp. And we're adding a new entry to the store facade on the north side of the building. That pretty much, there's no additional parking or anything else required. That's pretty much all I got for it.
Have you received a copy of the staff recommendations?
Yes, I have, we have no problem with them.
Okay, other than the sign, are there any color elevations to go with this rendering?
I'm sorry?
Are there any color elevations that we can look at?
Basically, we're going to match on the lower right side of sheet A201 is the colored pictures of the existing conditions. We're not changing anything other than the signage. It's just strictly adding signage and the door locations. Nothing else has changed. The colors stay the same. The colors stay the same. The window treatments are going to, they'll do some window treatments, and that's it. There's really no changes in color of the building or anything like that.
All right, Mr. Roseberry. Councilors, anyone in the public on this application?
There's not.
Any board members have questions?
No.
That's 1 out of 6, but okay. May I have a motion, please?
Mr. Chairman, I make a motion to close this public hearing and place it on the decision calendar. This is Stephen Walutis.
Motion to close by Mr. Walutis,
Mr. Chairman, this is Pete Zarcone. I second that motion.
seconded by Mr. Zarcone. Ms. Kelly?
I vote aye.
Ms. Dunn?
Is the
Aye.
tax that I missed?
Mr. Smith?
Aye.
Mr. Rose?
I vote aye.
The chair votes aye. Motion carries 7-0. Thank you, Mr. Roseberry.
Thank you.
Item number 4, Dunkin' Donuts freezer box at Ridge.
Yeah, the project is located at 1760 Route 112 in Ridge. It's zone J Business 2 with a lot area of 11,073 square feet. The applicant is requesting permission to legalize a 26.5 by 6.4 freezer box at the rear of the existing takeout restaurant. Staff recommends approval of the request with 8 staff recommendations, last dated 1/5/21.
Thank you, Commissioner. Is the applicant present?
Yes, I have Mr. Gallo.
Okay, you hear me?
I can hear you.
Okay.
You have video?
Yes, I do.
Okay, can you please raise your right hand, Mr. Gallo? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth to help you God?
I do.
Okay, Mr. Gallo, long time no see. How are you doing?
Very good. Very good. Doing well. But too much of a recluse right now. What with this pandemic? But
Okay, well, we'll get through it.
I just want to say good afternoon to the board, and I want to give you an update over the course of the last month so that you have an appreciation of our attempts to certify this project. On December the 9th, 2020, the Zoning Board of Appeals did grant us relief for the rear yard freezer. There was a rear yard setback encroachment and also a buffer encroachment, and we got full relief regarding that buffer. On December 29th, we applied for permit renewals for the signs and the awnings, the interior alterations, and we're awaiting those new permits. On December 31st, upon the direction of the inspector, I did secure the debris affidavits that he requested. On January 14th, we did get the health department sign off. I do have the final survey ready for submission to the planning board, to the planning division. And on January 21st, thanks to Robert Schroeder, I did receive from the planning department all the recommendations that he recommends or that the staff recommends to the board to complete the project. And we are in agreement that we will address each and every one of them.
Thank you, Mr. Gallo. Counselor, is there anyone in the public on this application?
No, I'm sorry. Did you hear me? There's no one.
No one, okay. Any board members have questions for Mr. Gallo?
I do, Mr. Chairman. This is Steve Walutis. Hello, Mr. Gallo.
Hey, how you doing, Steve? How are you?
Good. In our paperwork, I noted that there's a language that said that facade renovations were made that did not match the previously approved drawings. Can you comment on that?
Yes, I happened to notice it in the email Schroeder sent to me. And I remember months ago, I had given him pictures to demonstrate the changes. And it is not in his staff recommendations too as well. So that was what was submitted. And I didn't hear anything beyond that, to be honest with you. So I guess I'll have to check with the staff to see if that's been finally addressed or not.
But what were the renovations that differed from the drawings?
I understand it had to do with the awnings and the signage, I believe. I think it was the awnings portion that you see there. Mostly the
It's the
awnings.
signage on the front. It's the awning. So I have up right now what was previously approved.
Can we see how it exists today?
This is how it looks today. Let me just move it over.
Okay.
And staff recommendation did include to approve this.
Okay. Great, thank you.
Any other questions by the board?
Yeah, Mr. Chairman, I have one question in regards to the staff recommendations. Number 4, is that handicap parking that we're talking for signage?
Yes.
Okay.
Yes, exactly.
Street view that it's painted out on the right-hand side there, but there's no signage.
All right, thank you.
Okay. Any other questions? May I have a motion?
No.
Mr. Chairman, this is Steve Walutis. I make a motion to close this public hearing and place it on the decision calendar.
Motion to close by Mr. Walutis,
Mr. Chairman, this is Pete Zarcone. I second that motion.
second by Mr. Zarcone. Ms. Kelly,
I vote aye.
Ms. Dunn,
Aye.
Mr. Smith,
Aye.
Mr. Rose,
I vote aye.
chair votes aye. Motion carries 7-0. Thank you, Mr. Gallo.
Okay, you're welcome.
Item number 5, 520 William Floyd LLC in Shirley is being held to March 8th. Item number 6 is a site plan with special permit. It's Brixmore SPE 4LP pad site at Port Jeff Station.
The application is for proposed construction of a pad site with an office and bank with accessory drive-through within the existing parking area of the existing Nesconset Shopping Center, which is located on the northwest side of Nesconset Highway, New York State Route 347. And the south road is Norwood Avenue, which is along this, it's on the north side of the subject site. We had previously seen this, and there was some comments from the DOT, which we did receive. So the staff is continuing to support its recommendations, which there are 10. Everything is last dated October 23rd, 2020, in addition to a special permit for a drive-through accessory to a bank.
Thank you, Commissioner. Counselor, is the applicant present?
Yes.
Yes, good afternoon, Mr. Chairman. Philip Butler with Farrell Fritz for the applicant.
Mr.
Good
Butler,
afternoon.
can you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Butler.
So this application was previously before the board on November 9th, I believe. We put on a full presentation at that time. The public hearing was kept open to address some outstanding comments from the board, or rather questions about the configuration of the central driveway, as the discussions with the DOT are currently ongoing and there are evolving comments regarding that driveway. We submitted additional materials in response to those questions from the board. We submitted that on December 1st of last year, which shows that paraphrasing, that regardless of what the discussions with the DOT are, the configuration of that central driveway will not be materially changing. And Aaron Macte of VHB is here on the line with us in case the board wants him to go into any greater detail on that specific issue. But With that noted, we don't really have anything further to add to the presentation. We have seen the proposed conditions of approval and the staff recommendation. We have no issue with any of that.
Thank you, Mr. Butler.
Thank you.
Council, anyone in the public on this application?
No, Mr. Chairman.
Board members have any questions, Mr. Butler?
No.
Mr. Chairman, this is Richard Smith. I just want to say thank you for sending the additional information that I had requested, and I was satisfied with what I looked at.
Happy to do it. Thank you.
Any other questions? May I have a motion?
Mr. Chairman, make a motion to close this public hearing and place the matter on the decision calendar.
Motion to close by Mr. Smith,
Second.
second by Ms. Dunn. Mr. Zarcone,
I vote aye.
Ms. Kelly,
I vote aye.
Mr. Walutis,
Aye.
Mr. Rose,
I'll vote aye.
chair votes aye. Motion carries 7-0. Thank you.
Thank you.
Okay, I'd like to go back to item number 1, which we're going to leave on the decision calendar. Item number 2, the Woodlands at Port Jefferson Station.
Mr. Chairman, I make a motion to approve a clearing limit increase from 70% to 80% with staff recommendations numbered 1 through 3, last dated January 22nd, 2021.
Motion by Mr. Smith,
Second.
second by Ms. Dunn. Mr. Zarcone,
I vote aye.
Ms. Kelly,
I vote aye.
Mr. Walutis,
Aye.
Mr. Rose,
I vote aye.
chair votes aye. Motion carries 7-0. Item number 3, Allied Physicians Group LLC at Rocky Point.
Mr. Chairman, this is Stephen Walutis. I make a motion to approve this application to split an existing vacant tenant space into 2 for proposed medical office use, including a facade modification, subject to staff recommendations 1 through 9, dated November 20th, 2020, as covenants and conditions of the approval.
Motion by Mr. Walutis,
Mr. Chairman, Board Member Pete Zarcone, I'll second that motion.
second by Mr. Zarcone. Ms. Kelly,
I vote aye.
Ms. Dunn,
Aye.
Mr. Smith,
Aye.
Mr. Rose,
Aye.
chair votes aye. Motion carries 7-0. Thank you. Item number 4, Dunkin' Donuts freezer box at Ridge.
This is Stephen Walutis. Mr. Chairman, I make a motion to approve this application to legalize 26.5 foot by 6.4 foot freezer box at the rear of an existing takeout restaurant, subject to staff recommendations 1 through 8, dated January 5th, 2021, as covenants and conditions of the approval.
Okay, motion by Mr. Walutis,
Mr. Chairman, it's Board Member Pete Zarcone, I'll second that motion.
second by Mr. Zarcone. Ms. Kelly,
I vote aye.
Ms. Dunn,
Aye.
Mr. Smith,
Aye.
Mr. Rose,
Aye.
chair votes aye. Motion carries 7-0. Item 5 is being held to March 8th. Item 6, Brixmore at Port Jeff Station.
Mr. Chairman, make a motion for a negative declaration.
Motion for a neg deck by Mr. Smith,
I'll second that motion.
second by Mr. Zarcone. Ms. Kelly,
I vote aye.
Mr. Walutis,
Aye.
Ms. Dunn,
Aye.
Mr. Rose,
Aye.
the chair votes aye. Motion carries 7-0.
Mr. Chairman, make a motion to approve the construction of a pad site, which is an office and bank with an accessory drive-through within the parking area of the existing Wisconsin Shopping Center with associated site improvements. Also make a motion to approve a special application for a drive-through accessory to a bank. And I make a motion to approve 10 land development regulation variances and 4 parking variances as submitted with staff recommendations numbered 1 through 10, last revised October 23rd, 2020.
Motion by Mr. Smith,
Second.
second by Ms. Dunn. Mr. Zarcone,
I vote aye.
Ms. Kelly,
I vote aye.
Mr. Walutis,
Aye.
Mr. Rose,
I vote aye.
the chair votes aye. Motion carries 7-0. MD 365. Counselor, have we Have we heard from the applicant? There was,
Yeah, yes, I believe that you could move forward with a denial per staff comments, 1 to 4, dated 11/6/20.
okay, Ms. Kelly,
Yes, Mr. Chairman, I make a motion to deny this application based on staff recommendations number 1 through 4, last revised on 11/6/2020.
motion by Ms. Kelly,
Chairman, I'll second that motion. This is Board Member Pete Zarcone.
Mr. Zarcone seconds the motion. Mr. Walutis,
I will vote aye.
Ms. Dunn,
Aye.
Mr. Smith,
Aye.
Mr. Rose,
I'll vote aye.
the chair votes aye. Motion carries for denial. Are we waiting for the BZA yet on the U-Haul, Counselor?
That's correct, yes.
Is there anything the board would like to discuss before we adjourn the meeting? Hope everyone stays healthy and we'll be in touch for the next week or so. Take care.
Okay,
Meeting
take care,
adjourned.
everybody.
Do I have a motion?
They
to
will,
adjourn?
everybody.
Mr. Chairman, I'll make a motion to
Well-
adjourn the meeting.
Motion to adjourn by Mr. Zarcone,
I
Second.
second that motion.
second by Ms. Kelly. Mr. Walutis,
Vote aye.
Ms. Dunn,
Aye.
Mr. Smith,
Aye.
Mr. Rose,
Aye.
chair votes aye, meeting adjourned. Thank you.